great lovers of good things, my good people of Ghana, is your Nigerian God pleasure bringing you political news in our channel, Ghanatube. All the news trending are all we bring your way to keep you glued and make you know what is happening in Ghana. As the government is actually doing everything possible to make Ghana very wonderful and rebrand Ghana again. Please switch.
Well, if for some reason you don't know what's going on, I'm going to give you the brief and then we are going to go into the response. It could be almost say England for lawyers equal England and the Commonwealth. What you see now, what you see say Commonwealth, you can say Commonwealth country, not just say countries are England for a year soon. You mean a Commonwealth for. Na enani yeti say yesi ekubia omoya lawyers a womu frisa amanaman we mu omo aba betron krata womo ema His Excellency John Dramani Mahama order say Chief Justice get to talk on one ya suspending no Mahama enye no nsanso emfa ne mbra biom na dia Mahama enye no etiambra. Even though it has gone to Supreme Court, the Supreme Court has ruled say His Excellency John Dramani Mahama de oye ni nano. It is according to law. Wontiamra biano. Enkrofo person mo treso mo de omunim in Ghana ye Supreme Court. And for people who don't know, Ghana Supreme Court ena etre emrase. The sole role of the Supreme Court is to interpret the Constitution. Supreme Court na etre emrase. It is a Supreme Court na etre emrase. Now they also ye England for lawyers. So person try and say unim say ye Supreme Court. It is not just an insult. It is not just only an insult. What you see, but you see, it's more like it gives that classism, elitism energy, condescending, intimidation energy. Because the opposite address, who the nipa SUB, who the unim see ye Supreme Court, unim see ye judges, right? Basically, but the Attorney General, the Office of the Attorney General, Oman Chahu, in send me by 1 hour and check. The Office of the Attorney General had a response about Betuja. Na the Attorney General is Kulisa Nkrofo. You read the response Attorney General no e de e bae na yenhwe Attorney General in semwa wono so aka. We see press release. The Honorable Attorney General's response to the joint statement by the Bar Council of England and Wales and Commonwealth Lawyers Association on the suspension of the Chief Justice of the Republic of Ghana. Also, this is the response by the Honorable Attorney General of the Republic of Ghana to the joint statement issued by the Bar Council of England and Wales and the Commonwealth Lawyers Association on August 14, 2025 regarding the suspension of Her Ladyship Justice Gertrude A.E.S. Tokonu, CJ, from the office of the Chief Justice of the Republic of Ghana. 1. Also, the government of Ghana acknowledges the joint statement's expressed concern for judicial independence and commitment to constitutional governance within the Commonwealth. It is, however, a matter of serious concern that the BCEW and the CLA issued the joint statement without first acquainting themselves, even in a very basic way, with the relevant constitutional provisions and the material facts of the matter. Now, Obi Biara Otie, the analysis I did, me reading microphone and crat and assemble me trem on the same microphone and as a Ghana man or Muyamokai. Emma, my second video no cram me tres and microphone or moon kuti Ghana man ye. That is a womo kasake Ghana man cram no moonim. I did the analysis, I said that because that was the first thing. The video moon that was the first thing I could arrive at. And it's not surprising, say, in the response of the Attorney General, the number 1 point, the nonsense Attorney General no worker. Attorney General is a more can say, now move some more crano, say Ghana man cramoon. Attorney General no person say, in some more can the Ghana man cramoon, Nankose Musia Ghana Mrano, Mokin Ghana Mrano, Namutim Nana see and Sana Mukasa. Because clearly, any person who reads that statement will know say, and Grofu wins some more can moon in Ghana Mra. And so I'm happy that the Attorney General is also siding with in some way kind. The first point I mean Miki and then also Attorney General Miki. Now the second point I'll say the suspension of Her Ladyship just no. Before I go to the I'm getting too excited over this response. I'll bring you the. I'm getting to a response. I'm don't let me cool down and read it well. But answer no, Mr. Obi a wutie me bia no, wa wutie me no, you know yourself. Se we fu asha se kese, and washa se we put you on weight. You see, senior nipa your body etino. So we be after 30 years. Now she has say we put you on weight, and now washa se we fu of her ladyship, Justice Tokonu CJ, strictly adheres to the provisions of the 1992 Constitution of Ghana, particularly Article 146, which prescribes the procedure and grounds for the removal of the Chief Justice and the removal of other justices of the Superior Courts from office. This process is clear, comprehensive, and has been faithfully followed as set out in the steps described below. Into the second point, we're trying to say, Sabe, ya sorry sa keke, ina Chief Justice you see, ye bia na yembra, ni di mraso. Na we di Ghana Article 146 na. Ube hune say, ye bia na yembra. Yembra na yedi so no any. The procedure under Article 146 was triggered by 3 separate petitions filed by citizens of Ghana alleging stated misbehavior and incompetence on the part of her ladyship, Justice Tokonu CJ. It's in Grofo miensa, ekuo miensa, in the share petition and say maame no waye nyema dia ensem fata se o se Chief Justice oye e no so tre se Chief Justice ya dia ensem fata se o so ya e was sent for petition. B. Following the receipt of the petitions, the President, acting under Article 1466 and in accordance with the decided cases of the Supreme Court of Ghana, referred the petitions to the Council of State for their advice on whether any of the petitions discloses a prima facie against her ladyship, Justice Tokonu CJ. The Council of State is a body of eminent persons chaired by a former Speaker of Ghana's Parliament. Membership of the Council of State includes a retired Chief Justice, a retired Inspector General of Police, a retired Chief of Defence Staff of the Ghana Armed Forces, a former Attorney General, retired Justices of the Supreme Court, eminent traditional leaders, and elected representatives of each of Ghana's administrative regions. And I like what the Attorney General is doing here. The Attorney General is sort of letting England lawyers know. Say, I say, se mu nim Ghana mra na ye tremu Ghana mra ne tre say president eti enya petition na emi kwan say president no eye say onu ankasa e kwa yi Chief Justice no. I was say president no o sha ase ekokohu the Council of State. Na Council of State may be decided. It will not just say Council of State will say be nya kwahwe kwafo bia. A former Chief Justice eka ho. Former leader of Parliament and Speaker of Parliament eka ho. Former IGP eka ho. Former retired justices of the Supreme Court eka ho. Traditional leaders eka ho. Into your bobo sankrofo atrom say decision we no say Chief Justice no ene aba mo nchen aba be ka hwere mo say ade we ene emfa mra kwan so a ye hwere mo say ade a esi ye no enye nkola bi na ekokoti na be decide say maame no ye yi no eye mpanyifo na atena se ehu ni se nsem a ye de ato maame ne so no eye nsem a eye serious. OCC copies of the petitions were sent to the Chief Justice for her preliminary response, and upon receipt the President forwarded copies to the Council of State. After considering the responses, the Council of State found that each of the 3 petitions establishes a prima facie case against her ladyship, Justice Tokonu CJ. So because Uyan Gofonin Krata no Mudeba na Assemble Akomo Samso can say as a president no my Chief Justice na training same inti Attorney General ne Krata na said Dabi President no Eden same my Chief Justice. My Chief Justice training same or then the response by no yeah the response no sound so combine Council of State. I see D. Once a prima facie case was established, the President, in consultation with the Council of State, constituted a committee to inquire into the matter as mandated by Article 146. The committee comprises 2 justices of the Supreme Court, one of whom serves as the chairperson, and 3 other members who are not lawyers, members of Parliament or members of the Council of State. Into a trade President Council of State for me prima facie every year no and a president no eba for me panel say investigate na panel no mo investigate no enye obi akeke chief justice nankasa colleagues and etia no so you see the explanation into unim kra unim I say after establishing the inquiry committee, the president acting in accordance with further advice from the Council of State as provided for under Article 146(10)(a) of the Constitution, suspended her ladyship, Justice Tokonu CG, from the office of the Chief Justice pending the outcome of the inquiry. And I've read this on this platform in the video I just posted. My read it say, President no Article 146(10)(a) what say President in suspend the Chief Justice no, and not President ni and this was when Ngofone Nkrata no more say Ghana Mrani say the only time I will be Chief Justice and say, oh yeah, ready until the Chief Justice no. Into more trend said that be Article 10(a) say President can go forward to suspend the Chief Justice after all the processes no were respected, and the President indeed has done so. I see. The government notes the joint statement's reliance on the Commonwealth Latima House principles. Ghana's constitutional framework is not only consistent with these principles, but also provides robust safeguards for judicial independence and procedural fairness. The process under Article 146 of the Constitution ensures that the President does not act unilaterally, but only upon advice and findings of constitutionally mandated actors and independent investigative bodies. The President does not participate in the inquiry, and by Article 146(9) is bound by findings of the inquiry committee. In Grofone se mo ka no mo ka so mo mbra and mo ka se mo mbra na de yate. Ghana ha se yenso ye mbra yenso ye yusu. Now what Article 146 ne krana? Sa Article 146 no. We declare President no need to know, and I've discussed this. So when you case we shall say earlier this year no, I discussed the Article 146 in its entirety. Emma me mamuti say the wording of Article 146 ne krana. President need to me because now say Constitution is share President say so we see into His Excellency John Dramani Mahama Krana only to me, and indeed that is what the Attorney General is saying here. The President is binded by the Constitution to carry out in some investigative bodies no edebeba only to me our beka so investigative body no say nti menye dabi. See 4. Regarding concerns about representation and participation in the proceedings, the Attorney General is confident that the inquiry committee established under Article 1466 and chaired by the Chief Justice's peer, a Supreme Court Justice, is acting within the bounds of the law. We also believe that the Chief Justice, like any other Superior Court Justice subject to such proceedings, receives all the protections available under Ghanaian law, including the right to legal representation of choice and the right to fully respond to the allegations. And the issue I want to raise here, and the Chief Justice need complain say or call committee this one or call inquiry board this one, investigative board this one. I said ye yaka debi. And Momoka say on one crowfu no take committee na moon. In some way Momoka so yanya wrote to be because you be yaka de. Bosu. Umani crowfu na teso na eyama. You see, Chief Justice no be assembly kwa die Supreme Court. Judges no some can say. And assembly me see obi bia wo nim Ghana mbre bia no wa we follow me channel we mra assembly sha say no me sure say wo hu Ghana mbre ni mukra. Because na assembly so my baba we di other mra kra say committee of inquiry tenasia. They have the right to set their own rules. Muni amoka isa asem no. To attre say committee ni rules are omo set no. Enye say committee ni pe. Intia na me say Chief Justice on their crocodile Supreme Court. Intia. Why is it that omo throw letter no? They are not speaking about the Supreme Court ruling. The third point, say as to suggestions of delay or procedural impropriety, it is important to emphasize that the committee is wholly independent of the executive arm of government and conducts its work in accordance with its own procedural rules, consistent with the constitutional principle of legality, fairness, and reasonableness. By the provisions of Article 146, all proceedings related to the removal of Superior Court justices are held in camera, and the President, like all other citizens, is not privy to them. However, it is unrealistic and unbelievable that an inquiry committee with two of the suspended Chief Justice's peers, one serving as chairperson, will deprive her of the safeguards of due process, particularly when it is public knowledge that legal counsel comprising distinguished legal academics and practitioners has continuously and ably represented her throughout the hearings, bearing in mind that the proceedings commenced only on May 15, 2025. Any suggestion of undue delay is, to put it mildly, grossly misplaced. It's in some way, Mamma and someone walker, any entreating ye, any ashadan yabo delay tactics, any way say, or say, I declare May 15th, ya, and I dear Nashasi. Mamma, my colleagues me no any board so intino Attorney General bisa England for judges and Timusu say, Mamma no Supreme Court judges in now for 4 and now you human any board so no Omobe no mamma ya yakayaka diana. Mwa jumu ha yebehe na mame nya ne yakayaka de odi ese ye numpo na mobeka obi anim se mame lawyers bebri are representing obi a otie okọ obi a wonim sitting de ekoso bia no enim se mame lawyers bebri akọ representing wo ho ya mo kwan mo akọ mento ba abontin na oba bekasa te se de ye ma ne kwan na mo so mo aso se ye ma ne kwan na ye ma ne kwan a ma nya mo se ye nkola nyama bi ne ye wa ha na nkola agro bi ne yedi omo moti board so omo nya nkola metena se ahwe se maami yebe di na brosa. The sixth point, it must therefore be emphasized that there has been no constitutional breach or executive overreach in the consideration of the three petitions. Applications for interlocutory injunctions and judicial review brought before both the Supreme Court and the High Court by the suspended Chief Justice and her associates in an effort to restrain or halt the inquiry committee proceedings have been duly considered and dismissed by the court as lacking in merit. We feel considerably reluctant to mention that the sound, including the very words of the BCEW and CLA joint statement, vividly clones the dismissed grounds which Her Ladyship, Justice Tokomu CJ, and her associates canvassed before the Supreme Court and the High Court. It's also important to mention that Justice Tokomu CJ has presented similar arguments in her case before the ECOWAS Court, which the government of Ghana is defending on behalf of its citizens. And you see exactly what I said. And now I'm reading Grofon and Kata, someone can say, my meaning someone will raise and one as England for lawyers is so raisy. And that's exactly what the Attorney General is saying here. I say someone will raise, my meaning they are called High Court or they are called Supreme Court. Judges need to really say, now sending yet there, in someone will raise in a new. Musumu koko pijamu huwa. Ma meaning someone na musumu babe raise. And the same in same na ma so they are to ECOWAS. Edi na mo yesa no mu yama motokra dedi ase de ma meaning no babe trongata na mamu. Enye sa no kan ba me media me de ka hu no. The seventh point, also the government of Ghana remains strongly committed to maintaining the independence of the judiciary, separation of powers, and the rule of law. Any suggestion otherwise is unfounded and risks distorting a constitutional process that is being conducted fairly, transparently, and in accordance with the law. And indeed, it is true. Abaino and I say this is a legal process. It is in the more culture Mahama say only state the Chief Justice. Not just say Mahama wombo Ghana mrengu. More lawyers no. Why will you talk that way? Why will you tell the president to come and interfere in a judicial process that is currently going on? That is ongoing. What you say? Basically, that's what they are saying. They are telling the president to reinstate the Chief Justice, not just a judicial process. President Lumbungu, is that not overreaching? Is that not the executive arm overreaching? Because you need to allow the judicial process to go on. The final point, finally, Neither the Latima House principles nor the Constitution prohibits the suspension of a Chief Justice once a prima facie determination of misconduct or misbehavior has been made. The suspension will, therefore, remain in effect until the Inquiry Committee completes its work and submits its report, to which His Excellency the President will adhere. Very simple. I say, mo kanekana. Imran interest Chief Justice di boni ayin to me, you know. Mukra mumbra ni mo. Won say Chief Justice di boni, I will say to me, you know. Nti afi adai. Owe no kan manisi so say Mahama won tie mo nne ntie mo china. Won fi mo nne fi mo china. Imran na be koso. DBC pamonya de mo beye. And this is coming from Honorable Dr. Dominic Akurutinda Ayini, MP. I like it. I am really elate. I am excited. That's what I say. Neniaje. Sa writings here. Dr. Dominic Ayini Ediaban. What treating ceremony. So now who read we now also England lawyer. Now still say one here. Then they were shall book. Mumbra. Now Manasi has always said more on social media. Also let them come and reinstate her. Mumbra na mumma reinstate you know. Please do well to like, comment, and follow. Put on notification bell so you get all our news one by one. Thanks, my people.